Hello and welcome again to Immigration News and Views. My name is David Nachman and I'm one of the managing attorneys at the NPZ Law Group, Nachman, Fulwani, Zimochek Law Group. With offices in Richwood, New Jersey, we also have an office in Midtown Manhattan, and we have affiliated offices in Canada, as well as Canadian lawyers here on our staff, and also an affiliated office in Mumbai, India. So today I wanted to spend a little time telling you about a meeting that I attended in the middle of October. It was actually on October 11th in the afternoon. It was an H-1B stakeholders meeting that was held while the federal government, of course, was closed down. But the federal government was good enough to aggregate a group of individuals in Washington, D.C. who were an H-1B team, who were piped in by video chat, video conference, to a meeting that was held at the 970 Broad Street office, the district office of the USCIS here in Newark, New Jersey. And we were good enough at that time to have several people who were on a panel that spoke intelligently about the H-1B non-immigrant visa and some very important issues surrounding the H-1B. And this is, of course, a very poignant area to discuss now for two reasons. One, of course, is the recent Infosys settlement, of course, really brings the whole H-1B issue, the use of the H-1B, and of course the use of the B-1 in lieu of the H-1B to the forefront as an issue for many of the Indian high-tech companies, as well as other companies that are in the high-tech area. In addition, and of course, the Indian community here in New Jersey has a vested interest in, in their staff and making sure that these businesses continue to be viable. And that's why the meeting was attended by a very significant number of individuals who are in the Indian IT community. In addition to that, of course, comprehensive immigration reform, as everyone knows, in S-744, deals with issues of the H-1B and H-1B dependency and seems to really put H-1B dependent organizations under the microscope and seems to be making H-1Bs much more highly scrutinized. And that's going to be one of the other issues that comes up with regard to comprehensive immigration reform. But in and of itself, this meeting was organized on October 11th to have an opportunity for individuals in the IT community to voice their concerns about how they are being treated with regard to H-1B applications that are being made, H-1B petitions that are being made by employers for which many RFEs are being issued by the USCIS. So a couple of the things. First of all, the meeting was attended, it was actually sponsored again by the Newark District Office. The District Director, John Thompson, was officiating at that meeting. In addition, Andrea Quarantillo, who is now retired, but she was the District Director in Newark, New Jersey, also the District Director in New York, and is now on contract with the USCIS to look into the quality of the services that are provided to the public. So it was excellent to have an opportunity to see my friend Andrea at this meeting and to discuss with her how she is working hard to ensure that the services of the USCIS to its customers are being handled in a high quality manner. In addition to that, William Slattery, who also is an individual who my partner Michael Fulwani knows for many, many years. William Slattery was one of the high-level directors at the USCIS with regard to the non-immigrant issues. He was there, and we had an opportunity to kick around some of the issues. So what came out of this meeting? Well, a couple of things, of course, was that the Indian high-tech community, representatives of the Indian high-tech community, had an opportunity to voice their concerns. And what their concerns were about mostly had to do with the fact that the government was focusing on them issuing inordinately long RFEs to make things difficult for those organizations. And I think that the message that was being sent across to Washington with regard to the H-1Bs and the scrutiny that's being given to the H-1Bs is that it's very difficult to do business. And one of the issues which I had raised standing at the microphone was that the Indian community should know that it's not being singled out. We represent IT companies from various countries around the world, not just Indian companies, but high-tech companies from Israel, high-tech companies from South Africa, high-tech companies from the UK, high-tech companies from Asia, other Asian countries. It's not just the Indian community. What's happening is H-1Bs in general are being scrutinized. And unfortunately, the reason for that has to do a lot with the fact that, and I call it the one bad apple spoils the whole bushel theory, is that unfortunately what ends up happening is when you have an organization that utilizes the H-1B improperly and brings scrutiny down on it because the H-1B is a fraudulent H-1B or it's misused, what ends up happening unfortunately is that the government then focuses its efforts on all H-1Bs across the board. So one of the points which I drove home at this meeting was that the Indian IT community should not feel that it's being discriminated against. Everyone's being discriminated against, and therefore, if everyone's being discriminated against, there's no discrimination. So that was one of the points which I made. And in addition to that, I guess one of the other things that came out of this meeting, which was really tremendous, was an opportunity to speak to the FDNS officer in Newark. His name is Art Clark. I've been working with Art Clark for many, many years. I find him to be incredibly professional and an asset to the FDNS team in Newark because he's very, very thorough. He happens to be a lawyer in his own right and extremely, extremely professional. He's always handled FDNS site visits and FDNS interviews in an extremely professional manner and has always seemed to be asking the right questions, very focused on what he's doing. What Mr. Clark assured us is that site visits were going to be increasing, and that is the mandate that's being sent out, and we, of course, spend a great deal of time trying to tell our H-1B clients to prepare for the site visits from the very beginning, make sure that the beneficiaries, the petitioner, the company knows what all the details are with regard to the H-1B, that you can't put your head in the sand. You really have to know the details because when and if a government officer shows up on site, they're going to have questions and you have to be prepared to answer those questions. I remind our viewing audience, as I did during the stakeholders meeting, that a FOIA request was submitted by the American Immigration Lawyers Association several years back, and one of the documents that came from the government was a worksheet that the contractors, now I say contractors because FDNS at that time used contractors who they sent out to do the site visits, and now we found out at this meeting that they're not going to be using contractors, that the individuals who are going to be going out and doing the site visits will be employees under the tutelage of the individuals who are heading up the FDNS units. So that's very encouraging to know because unfortunately, back when the site visits first began, we didn't find that there was a very high level of training that was being given to these contractors. But again, coming full circle, what our viewers need to know is that there are worksheets that are available, and you can get these worksheets online so you can prepare yourself potentially for a site visit. And the idea, of course, is to have the information that you need in order to prepare yourself so that when a site visit is made, you can give the officer everything they need, and then, of course, they don't have to keep coming back. The idea is to conserve government resources by giving them the information that they need when they ask for it, as opposed to them having to come back and you having to go back and, you know, trading calls, and that is a big waste of time. So one of the other things that we talked about was the ability to have legal counsel during the site visits, and of course the government reassured all of the individuals, the stakeholders at that time, that they could have legal counsel if they wanted to. However, the need for legal counsel during a site visit was absolutely not necessary, and our personal opinion is that a site visit does not require a lawyer to be there. However, again, going back to what I was saying before, is that an employer can be prepared enough for a site visit, have all of the details, and appoint a point guard, a person in your organization who has all the information readily available, and tell your receptionist that if someone shows up from the government, of course, find out where they're showing up from, what organization, because that's going to tell you what type of an investigation or administrative action may be taken against the employer. But make sure that receptionist knows the person within the organization to whom that person can be directed, so the appropriate information is given to them. A couple of the other things that were discussed at that meeting, at the stakeholders meeting in Newark on October 11th, had to do also with H-1B dependency, and also there was discussion about the ability or the need to post LCAs where individuals were being transferred, and what would happen if the organization to which the individual is being transferred doesn't allow the LCA to be posted. So these were all very interesting questions which were posed to the USCIS team in Washington, D.C. Some of the questions were answered clearly and succinctly. Some of the questions, unfortunately, were not. Now, in addition, the H-1B team in Washington, D.C. shared with us a PowerPoint presentation, and it was an excellent PowerPoint presentation about the generalities of the H-1B non-immigrant visa petition, and who qualifies for H-1B status and who doesn't. And actually, one of the things that I had asked for is a copy of that PowerPoint presentation. I just want to bring to the attention